কিন্তু কি বলছে যে কন্ট্রাক্টর ইজ নট পার্টি বলে দিচ্ছে। আপনি যেটা বলছেন এফিডেভিট হয়তো 25/6 দেখো you see this is no, you had filed an affidavit on 13/10/2025. In this affidavit, paragraph 3F at page 4, you have taken a stand that the petition suffers from non-general necessary parties as the contractor executing the ongoing works have not been implemented. But they are respondent number 12 already there.
Yes, my lord. And after that, there are lots of additional affidavit that has been filed, my lord. If
No,
I may
but-
kindly draw your lordship's
No,
attention.
but is this stand correct that the contractor is not a party? Okay, after that they have implemented.
My lord,
Okay.
initially they were not
Okay,
made a party.
Okay.
Yes,
We stand corrected. Okay, then we adjourn the matter because of the weather. This part of the work cannot be done. The bitumen and those works cannot be done now. All sides are represented. The learned counsel for respondent number 12 refers to the additional affidavit filed on 10/8/2026 and has submitted that the respondent number 12 has mobilized the men and materials and are ready to do the balance DBM and BC works, which could not be undertaken due to the prevailing wet weather. Stop. As a copy of the said affidavit has been furnished to the NHI DCL, on the next date of listing, the respondent number 7, NHI DCL shall submit a report on the stand taken by the respondent number 12 after physical verification. Next para. The matter stands adjourned today. List after 2 weeks. 2 weeks.
Approximately after 1 month, Lordship. In case if we get some time, we will be able to improve our progress also. So in fact, in the meanwhile, they can carry out the inspection and other things.
Okay. List after 4 weeks.
Can it be 9th of September in case if the diary allows? That's Wednesday.
Item number 2.
May it please, my lords, on behalf of the state respondents, my lord, we are yet to file an affidavit in opposition, my lord. Your lordship can grant us 3 weeks' time.
But the procedure in this bench appears to be a bit confusing. The court on the last occasion on 1/7 issued a notice to the Advocate General. Why it should go by post? Why there's no one here to receive it? Advocate General, we are not supposed to send it by registered post.
Yes, my lord.
So why is this prevailing here?
My lord, we have served extra copies to the Advocate General, my lord.
No, but the report says has been sent by speed post, AD card has been returned, duly served. This is not how we issued notice to the Advocate General. And what is the instructions from the Advocate General?
Lord, we are waiting for the pair-wise comments, my lord. There's a challenge to the rules, my lord.
Yes.
Yes, my lord.
Both sides are represented. Notice on the Advocate General has been served. Next, the Learned Additional Advocate General prays for and is granted 3 weeks' time to file affidavit in the matter. Next, list after 3 weeks.
Deeply obliged.
Item number 3.
Just write the names and give it to him. Huh?
Your lordship, I have forwarded the notice to the informant to the concerned OC, that is Dungtang Police Station, Sampai District, on 8 June 2026. However, yesterday when I did not receive any return from the concerned OC, I have contacted them and resent via WhatsApp the form again. So if I may be given another week time to serve the notice, your lordship.
10 minutes.
And meanwhile, the TCR from trial court has been duly received, so paper book may be prepared.
In this regard, we would like to have a meeting with your police administration. Anybody who is next to your DGP, you have to ask him to meet us. We are here for 2 working days more. Because this system has to be, the ecosystem with regard to the issue of process to be served through the police station, that has to be, it should be streamlined. can you make a request to the DGP to ask any officer subordinate to him to please come and meet us for 10 minutes?
Yes, Your Lordship, if that could be reflected in the order itself, Your Lordship, in this order itself. It, Your Lordship, they know that they have to inform
No,
the,
that ecosystem means there must be a SOP or a direction from the DGP that process is issued in respect of the complainant or the victims of POCSO cases. It has to be served and the service report returned. Because if they don't return it,
Your Lordship, they have returned in numbers of cases.
we understand. But even in one case, if they don't do it, it is a disrespect to the order of the court. When we have said return it on a particular day, even if they don't send it, they have to send at least something that the process will be returned after some time. At least that ecosystem might be there. We don't insist on physical reports. It has to come through email also
Yes.
to your office and it can be produced before us. It is only for that reason. Okay. Third, you also need to speak to the registrar. Please tell them. After the court rises, we'll have a word with them also. You see here also the same system. The registry is issuing notice to you
Yes.
to send it to police station through registered post.
Yes, that is the practice that we are doing.
No, this is stop. You are the officer of the court. You are available in the office. You are the establishment of the public prosecutor is there in the court building. Why registered post? Can't somebody walk from one wing to another to give it to you? The postal money does not come for free. The state is paying it. Why all this? No.
Your Lordship, this pertains to Deepak Nair versus State of Assam. I do not have the judgment in hand, but I have it in my phone, Your Lordship. We have been doing this since 2024, if I'm not mistaken, Your Lordship. This was
You see, it says PP, additional PP, GSC AB. AB is Aizawl bench. Then next notice is sent to Mr. Lalro Kungo.
Yes.
I can't spell it. PAUTU.
the learned counsel for the amicus curiae. Yes.
Advocate GSC AB. To them also it is sent by this registered post. Now, if for the public, you see, it's a very simple legal proposition. In a criminal case, Section 27 of due service of notice after 30 days is not permissible. In a criminal process, it must be served to the person concerned. Presumption of service cannot be drawn. It is there in CPC alone. Now, what happens if this AD card continues and we don't serve it to you and the counsel? What happens? Prayer for bail, prayer for suspension of sentence will linger on for years together. This is not the process. The government advocates are here, PP are here. Advocates are here. You can be notified. In my scroll, I can notify the lawyers to come and then pick the document up. This is impermissible for the registry to send it like this. First is sponsored on a legal aid counsel. You are legal aid counsel or amicus? Amicus curiae for the appellant. For the appellant who is presently in jail. Full stop. Pursuant to order dated 20 May 2026, notice was issued to the public prosecutor for service of notice on the complainant or the informant through the jurisdictional officer in charge of the police station concerned, and Mr. Lal Rokunga, LLROKUNGA, or to PAUTU, was appointed as an amicus curiae. Full stop. Though the office of the public prosecutor, Mizoram, is situated in the campus of this court, the registry अच्छा, it will, let me say, special messenger. It's also a special messenger.
Your Lordship,
85 return. Also, 85
DB bọc xe xí đề lui đến nó bị tóc này không? Giặc chiang bọc xe.
Vice proposed. Okay. Don't write that word registry. Huh? Stop. Next.
Your Lordship,
The learned APP submits that the process has been sent to the concerned police station and the service report is awaited. Next para. It appears to the court that the service of process on the complainant of the victim perpetrators have the victim in cases under POCSO Act is required to be served to the
British Your Lordship, the meeting notice which pertains to 66 of 2024. 66 of 2024 was disposed of at the motion stage. It was held that it might be covered with this judgment and order. I have given the copy to the court officer.
So even if 66, even while deciding that meeting, that point of time you knew that 64 and 52 are
Yes.
being complied with or are awaiting compliance. Even at that stage, the government did not move for a 60 for an appeal in 64 or 52.
It was disposed at the motion stage, and government was given liberty to scrutinize the matter. I'm not very sure, but I think contempt petition is pending in the matter, Your Lordship.
Advertisements are considered without prosperous advertisement. Divide only the persons who will be serving or anybody and everybody. We give it to advertisement. Advertisement of activity another advertisement of benefit. And the does not benefit our service the protection the normally I have obligation to use it.
Yes.
So, Your Lordship, as per my submission, Your Lordship, the government, even though there is some delay, has remained active in pursuing the judgment and order, Your Lordship. Now, it's a little bit hard for me to differentiate how to draw the line between the 52 and 64. However, the only submission in that regards that I have is that just because we have made a mistake does not give them a negative right to claim it as a matter of Your Lordship. That's why we have this one of the court. Now 66. Now 66 of 2025 cases was disposed of at the motion stage, Your Lordship. And it was held to be covered with the same judgment and order. However, appeal was not preferred in that case because the main case wherein this it was based, that is the present cases, preferred appeal.